Rome Statute of the International Criminal Court, Role of States in Enforcement of Sentences of Imprisonment. Part 10. Enforcement. Article 103. Role of States in Enforcement of Sentences of Imprisonment. 1a. A sentence of imprisonment shall be served in a state designated by the court from a list of states which have indicated to the court their willingness to accept sentenced persons. b. At the time of declaring its willingness to accept sentenced persons, a state may attach conditions to its acceptance as agreed by the court and in accordance with this part. c. A state designated in a particular case shall promptly inform the court whether it accepts the court's designation. 2a. The state of enforcement shall notify the court of any circumstances, including the exercise of any conditions agreed under paragraph 1, which could materially affect the terms or extent of the imprisonment. The court shall be given at least 45 days' notice of any such known or foreseeable circumstances. During this period, the state of enforcement shall take no action that might prejudice its obligations under Article 110. b. Where the court cannot agree to the circumstances referred to in subparagraph a, it shall notify the state of enforcement and proceed in accordance with Article 104, paragraph 1. 3. In exercising its discretion to make a designation under paragraph 1, the court shall take into account the following. a. The principle that states parties should share the responsibility for enforcing sentences of imprisonment, in accordance with principles of equitable distribution, as provided in the Rules of Procedure and Evidence. b. The application of widely accepted international treaty standards governing the treatment of prisoners. c. The views of the sentenced person. d. The nationality of the sentenced person. e. Such other factors regarding the circumstances of the crime or the person sentenced, or the effective enforcement of the sentence, as may be appropriate in designating the state of enforcement. 4. If no state is designated under paragraph 1, the sentence of imprisonment shall be served in a prison facility made available by the host state, in accordance with the conditions set out in the headquarters agreement referred to in Article 3, paragraph 2. In such a case, the costs arising out of the enforcement of a sentence of imprisonment shall be borne by the court. Article 104. Change in designation of state of enforcement. 1. The court may, at any time, decide to transfer a sentenced person to a prison of another state. 2. A sentenced person may, at any time, apply to the court to be transferred from the state of enforcement. Article 105. Enforcement of the sentence. 1. Subject to conditions which a state may have specified in accordance with Article 103, paragraph 1, b. The sentence of imprisonment shall be binding on the state's parties, which shall in no case modify it. 2. The court alone shall have the right to decide any application for appeal and revision. The state of enforcement shall not impede the making of any such application by a sentenced person. Article 106. Supervision of enforcement of sentences and conditions of imprisonment. 1. The enforcement of a sentence of imprisonment shall be subject to the supervision of the court and shall be consistent with widely accepted international treaty standards governing treatment of prisoners. 2. The conditions of imprisonment shall be governed by the law of the state of enforcement and shall be consistent with widely accepted international treaty standards governing treatment of prisoners. In no case shall such conditions be more or less favorable than those available to prisoners convicted of similar offenses in the state of enforcement. 3. Communications between a sentenced person and the court shall be unimpeded and confidential. Article 107. Transfer of the person upon completion of sentence. 1. Following completion of the sentence, a person who is not a national of the state of enforcement may, in accordance with the law of the state of enforcement, be transferred to a state which is obliged to receive him or her, or to another state which agrees to receive him or her. taking into account any wishes of the person to be transferred to that state, unless the state of enforcement authorizes the person to remain in its territory. 2. If no state bears the costs arising out of transferring the person to another state pursuant to paragraph 1, such costs shall be borne by the court. 3. Subject to the provisions of Article 108, the state of enforcement may also, in accordance with its national law, extradite or otherwise surrender the person to a state which has requested the extradition or surrender of the person for purposes of trial or enforcement of a sentence. Article 108. Limitation on the prosecution or punishment of other offenses. 1. A sentenced person in the custody of the state of enforcement shall not be subject to prosecution or punishment or to extradition to a third state for any conduct engaged in prior to that person's delivery to the state of enforcement, unless such prosecution, punishment or extradition has been approved by the court at the request of the state of enforcement. 2. The court shall decide the matter after having heard the views of the sentenced person. 3. Paragraph 1 shall cease to apply if the sentenced person remains voluntarily for more than 30 days in the territory of the state of enforcement after having served the full sentence imposed by the court, or returns to the territory of that state after having left it. Article 109. Enforcement of fines and forfeiture measures. 1. States parties shall give effect to fines or forfeitures ordered by the court under Part 7. Without prejudice to the rights of bona fide third parties, and in accordance with the procedure of their national law. 2. If a state party is unable to give effect to an order for forfeiture, it shall take measures to recover the value of the proceeds, property or assets ordered by the court to be forfeited, without prejudice to the rights of bona fide third parties. 3. Property, or the proceeds of the sale of real property or, where appropriate, the sale of other property, which is obtained by a state party as a result of its enforcement of a judgment of the court shall be transferred to the court. Article 110. Review by the court concerning reduction of sentence. 1. The state of enforcement shall not release the person before expiry of the sentence pronounced by the court. 2. The court alone shall have the right to decide any reduction of sentence, and shall rule on the matter after having heard the person. 3. When the person has served 2/3 of the sentence, or 25 years in the case of life imprisonment, the court shall review the sentence to determine whether it should be reduced. Such a review shall not be conducted before that time. 4. In its review under paragraph 3, the court may reduce the sentence if it finds that one or more of the following factors are present. A. The early and continuing willingness of the person to cooperate with the court in its investigations and prosecutions. B. The voluntary assistance of the person in enabling the enforcement of the judgments and orders of the court in other cases, and in particular providing assistance in locating assets subject to orders of fine, forfeiture or reparation which may be used for the benefit of victims, or C. Other factors establishing a clear and significant change of circumstances sufficient to justify the reduction of sentence, as provided in the Rules of Procedure and Evidence. 5. If the court determines in its initial review under paragraph 3 that it is not appropriate to reduce the sentence, it shall thereafter review the question of reduction of sentence at such intervals and applying such criteria as provided for in the Rules of Procedure and Evidence. Article 111. Escape. If a convicted person escapes from custody and flees the state of enforcement, that state may, after consultation with the court, request the person's surrender from the state in which the person is located pursuant to existing bilateral or multilateral arrangements, or may request that the court seek the person's surrender, in accordance with Part 9. It may direct that the person be delivered to the state in which he or she was serving the sentence or to another state designated by the court.